Your information is not safe. The internet is a cesspool of lies and deceit, and a thief who would once steal your wallet or your purse now sits behind a desk in a dark room, steals 1,000 credit card numbers with a single click of a mouse. During the 1990s, the internet rapidly expanded with the invention and mass discovery of the World Wide Web, which is a small facet of the internet. It became a medium for the communication and a source of the retrieval for information on almost any topic imaginable. This sudden growth caught the American legal system by surprise. Before 1996, Congress had passed very few laws which pertains to internet as a form of telecommunication. According to the Gale Encyclopedia of American Law, the earliest privacy-related law regarding the internet was the 1966 Electronic Communications Privacy Act, which essentially made it illegal to read private email. The law basically extended to protections already provided by laws in place applying to in-person mail. It was essentially made to make it illegal to read private mail. The law was basically intended to provide companies with a legal recourse for industrial espionage. According to the Encyclopedia of Management, the only exception to that law was subpoenas issued during a criminal investigation and more recent interpretations of the law by federal courts, which grant employers the ability to securely monitor an employee's email on company-owned computers or using company-owned email addresses. Criminal activity on the internet is classified and generalized as computer crime and include a number of different crimes such as intellectual property theft, stealing, such as account passwords, credit card numbers, and personal data. A majority of laws after 1996 focus more so on the content of the internet as opposed to the way it was retrieved. The advent of social networking dynamically changed the implications of privacy on the internet. Information shared among users on social networks is never private. The internet is a public domain, and the World Wide Web is a public place. A majority of social networking sites are open for the public to freely join. Anything one places online, be it personal information or a picture, a document or data that someone has created, and that becomes immediately available to everyone that accesses that site. This data, even when it's deleted, removed, or restricted, is still available to outsiders who are capable of accessing hidden information. Computer security experts, such as those listed in the Impact and Implications of Technology article, suggest that people use limits to the amount of personal information they make available online. Often, teenagers completely unaware of the implications of their data use will post far more than they really should online. According to a 2000 study conducted by Cox Communication and the National Center for Missing and Exploited Children, 71% of teens ages 13 to 17 had personal profiles on social networking sites like Facebook and MySpace. Half of the teens surveyed expressed little or no concern about posting personal information online, even when much of the data can be viewed by anyone accessing the site. The survey shows that teens frequently post the following types of information on their social networking sites. 64% posted photos or videos, 58% posted information about their hometown, 49% posted their school's name, and 8% posted their actual cell phone number on the site. More often, people fail to realize that their future employers will actually view that information when they're searching for a job or an applicant. According to Bits and Bytes, 75% of job recruiters actually use social networking sites to scan and screen potential applicants. We do, however, have some protections against unwanted eyes on our information. The Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The popularity of the Internet has greatly increased the number of cases in which the Fourth Amendment and the use of the Internet intersect. The general court consensus, based on interpretation of the Fourth Amendment, has continued to apply the same rules regarding searches and seizures within the domain of Internet and technology use with physical information. According to the Gale Encyclopedia of American Law, and most importantly, the court has found that users who use social networking sites, as well as communicate via chat rooms, electronic bulletin boards, or peer-to-peer technologies, forego and do not enjoy a reasonable expectation that their data will remain private. A major groundbreaking case referenced in the Encyclopedia of Business and Finance was the case of Gonzalez versus Google, in which applied to a government request search of Google servers to reveal user search history and compare it to URLs. Google indicates that it should not be held responsible for the security of query data. It does not indicate that it will protect personal data. However, the court ruled that it would be unreasonable for users to expect Google to protect query data, but did concede to allow Google to only share non-personal information as part of the investigation. As of 2009, there is additional software available to tap Internet connections of private residences and companies to use with the issuance of subpoena by federal authorities, police departments. Ultimately, the Internet is a public network, and one must remember this when adding information to the web. Fortunately, the Fourth Amendment provides us with some legislation to offer legal recourse for actions taken against us by illegal use or by the government, and it is the responsibility of every user to be aware of the content they upload and monitor their usage with the knowledge that essentially anyone with an Internet connection can access that.